Good afternoon, Mr. Garcia.
Excuse me?
I said good afternoon.
Good afternoon.
And the second time that you came up, you knew he was going to be taking the children to school, and so you followed him to the school, correct?
The daycare, yes.
Yes. And then you knew he was going to be going to the gym, right?
I didn't know he was going to the gym. I just followed him.
You followed him to the gym.
Yeah.
Okay. And then you followed him to his house.
Yes, ma'am.
And that's where he was killed.
Yes, ma'am.
And the woman who wanted him to be killed, past you and Sigfredo and Katie, the woman who wanted him to be killed was Wendy Adelson, correct?
Yes, ma'am.
It was she wanting her children, correct?
Absolutely.
Mr. Garcia, I'm going to show you what
With
has
Mr.
been-
Rivera.
Oh, I'm so sorry. I am so
Twice.
sorry. I apologize.
Have you previously referred to a dentist being involved?
Yes, ma'am.
Who was the dentist?
Charlie,
And how was he related?
Katie's boyfriend, side piece, whatever you want to call him.
All right, so Katie was the wife of Garcia, but also the girlfriend of the dentist?
Yeah.
There's volume 1, volume 2, volume 3, volume 4, volume 5.
Is there a question to the witness?
Do you recognize this file?
Yes, I think I forwarded this to you.
And are these 10 volumes a example of a hotly contested relocation case?
Well, and I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
Please sit down, Ms. Bailey.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have
Members
the...
of the jury, the bailiff will take you to the jury room.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well-
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended, if that's...
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
it was set for May 15th and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes.
This is on behalf of myself and my wife Susan Brotman, an attorney at law. We have known Donna Adelson for over 35 years. She's been a dear friend and travel companion, and we are still in shock of her current circumstances. We know her to be a loving parent, wife, and grandparent. We stand behind her claim of innocence. We feel the trial was held in a county where there's been a lot of bad and inaccurate negative publicity, therefore not allowing a fair trial. We contend if a change of venue was granted, she would have been found not guilty. We are hopeful she will be relocated to South Florida, where she can pursue all legal remedies available. Thank you very much for your consideration.
These are character statements or quibbling about the evidence and the rulings?
It's character, Judge. They're here to talk about their friendship and time. Thank you.
Any witness examination for Mr. Chagrin?
Captain.
No, Your Honor.
You may be seated.
Thank you, Judge, and respected officers of the court for allowing me to speak. I have been Donna Adelson's husband for over 50 years. My wife sacrificed everything so that she could pour her heart and soul into our children, our grandchildren, and our marriage. This summer was our 54th wedding anniversary, and I had to spend it without her, hand in mine. She has done nothing wrong, and yet is being punished for a crime that she did not commit. I thought we lived in a different kind of world, but I guess I was wrong. I have listened, watched, and sat in the courtroom for the entire trial, and I could not help but scream in my mind by the witnesses that were brought forward by the prosecution who told outright lies. I didn't know that you could lie in a courtroom, but apparently you can. Danny's parents contend that they have never seen their grandchild. But for years they say they've never seen her. But Wendy has shared with me pictures and videos and letters from their visits. They have suffered immensely at the loss of their son, but they also contend to tell lies to the court about our grandchildren. Donna has always been a loving and caring wife and is innocent of the charges. A biased judge and jury were influenced by years of one-sided news pieces and social media.
Doctor, Ms. Fulford, this has nothing to do with the character of the defendant or relates to sentencing.
May I have just one moment, please?
Go ahead.
Thank you.
All right, thank you for letting me continue. Donna did not participate in the heinous acts that she was convicted of doing. You are sending an innocent woman to prison. You have taken my wife and you have taken my life as well. And for what? This is not justice. It is vengeance, and it is wrong.
Do you have an examination for Dr. Adelson?
No, Your Honor.
We don't have any further witnesses, Judge, but Mrs. Adelson has decided she would like to make an unsworn statement to the court.
Unsworn?
Yes, Judge.
All of the witnesses will be sworn this afternoon if she wishes to speak.
Judge, the case law indicates, confirms that the defendant has the right to make an unsworn statement prior to sentencing.
Seeing in the case where it does state the defendant has a right to make an unsworn statement, we will proceed.
Thank you, Your Honor.
Thank you for letting me speak. My son-in-law, Dan Markel, was a fine and decent man. He was well educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18th, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them, and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." But pictures and memories are all they have, because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without the father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is what they call the, quote, mastermind behind this murder. In both of Katherine Magbanua's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case. Where is the evidence before July 18th, 2014 at 10:50 in the morning?
Before you continue,
That
Mrs.
revealed-
Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
No, Judge, just giving
I-
Adelson an opportunity to be heard.
Mrs. Adelson, you certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show that there was evidence before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop, to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media, printed news, television news, and podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, "I believe she is guilty." Not one person, not one, said, "I think she may be innocent." That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror.
Mrs. Fulford,
Oh, I didn't hear you.
Mr. Zellman, again, this has nothing to do with elocution of any sort. This is a raising of grievances which are properly given to the appellate court. What does any of this have to do with sentencing?
Could I have just one moment, please?
Turn that phone off or step out.
What happened to Danny is unforgivable, but I am an innocent woman convicted of this terrible crime without evidence. Danny was a brilliant legal scholar. He would have been appalled at the total lack of justice that went on during my trial. He would have been embarrassed to have his name associated with any of it. There are 2 crimes here. The first was Danny being viciously murdered. The second one is taking my life, the life of an innocent woman. Convicting me should not be retribution for Danny's death. That is not justice for Dan. I've always respected the law. I've never gotten a parking ticket, but I'm going to prison for a murder I did not commit. I do intend to file an appeal so that hopefully I have the opportunity to be given a fair trial outside of Tallahassee. 11 years ago, Danny was murdered and taken from all of us who loved him. For the past 9.5 years, the state has broadcast to the world, including Danny's parents and sister, that I hired hitmen to kill him. Never in a million years would I have wanted Danny to be harmed or killed, nor could I ever do something that would leave these 2 small boys to grow up without him. I love these boys more than life itself. This is a lifetime of loss for these children. They didn't deserve this. His family didn't deserve this. Danny didn't deserve this. And so, As I appear before you today, Your Honor, I promise you with my whole heart, I swear to you on my life, I was not involved in any way with Danny's murder. I was not.
Defense have any further argument to make?
Yes, Judge.
Judge, before Ms. Fulford makes the argument, I want to address a comment that the court made a few moments ago concerning considering lack of remorse in fashioning a sentence. In Shepherd v. State 227 Southern 3rd, 746, the First District Court of Appeal held that lack of remorse cannot be considered in fashioning an appropriate sentence. If this were a situation where remorse and admission of guilt may be grounds for mitigation, the lack of these factors cannot be used to increase the defendant's sentence, and such reliance violates the defendant's due process rights. And they also rely on Ritter v. State 885 Southern 2nd 413, also a first DCA case.
I believe the Supreme Court has ruled on this issue concerning remorse and lack of showing remorse as well. If you need me to find the citation for you, I will.
Yes, please.
Going to read from Head Note 8 and 9. Nor was Davis forced to choose between allocution and maintenance of his innocence. He certainly could have allocuted without voicing his disagreement with the verdict, blaming the driver, the police, his lawyer, the trial court for his conviction, and attempting to explain his personal interpretations of the law to the judge. He could have asked for leniency without admitting guilt. He could have provided the judge with reasons to impose a sentence less than the maximum besides his claimed innocence. But he instead chose to make a lengthy statement claiming innocence, denying responsibility, and placing blame for his conviction on the alleged misconduct of others. The trial court was under no obligation to ignore such statements and did not err in considering those statements and imposing the legal sentence here. Do you have anything that distinguishes Davis in any way?
As I said, Your Honor, Davis was not a capital case.
Very well. Any other argument or evidence the defense wishes to present?
Yes, Judge, thank you.
Please move forward.
Up until the point of the homicide, the only evidence that was presented about Mrs. Adelson's participation were those ugly emails. And there's a distinction, as we discussed during the trial and sometimes even at sidebar, of the evidence being up to the moment that Mr. Markel was killed. Up to that time, the only evidence introduced by the state in this trial for that time period were those ugly emails, and they were ugly. She called him very foul names. She said some ugly language. She clearly was not happy. And whatever conversations may have taken place while Katherine Magbanua was inside Charlie Adelson's home and Charlie was outside talking to another person. Mrs. Adelson maintains her innocence. But if you're looking at this particular cause of this disparity in treatment, the state is asking that Mrs. Adelson be sentenced to obviously life on count 1 as she has to be, followed by 30 years in the Department of Corrections on counts 2 and 3. This is far in excess of the sentence that was received by the man who himself testified to hunting down Danny Markel, providing the gun for him to be murdered with, leaving the scene of the crime, disposing of the murder weapon, and going on with his life in his gang as he always had. In that disparity, Judge, it just doesn't reconcile with the facts here of what they say Mrs. Adelson did. Although there was a theme that she was the mastermind, I would argue to the court that the evidence did not show she was the mastermind in any way. The masterminds that were shown in this trial were Charles Adelson and Katherine Magbanua. It didn't show any activity prior to Mr. Markel being killed where Mrs. Adelson was involved in any way.
Take away what you're arguing as the theme for the moment. The chief difference between Luis Rivera and your client as he entered into a plea, correct?
That's correct. He did enter into a plea, but that, according to the case law, that can be considered.
And he has also cooperated with the state, testifying in many trials.
He was a cooperating witness testifying in these trials. Mrs. Adelson not only has maintained her innocence, she was never offered anything from the state. I do want to remark, if I may, just briefly on the issue of remorse. Mrs. Adelson maintains her innocence, and as she has a lawful right to do, will seek an appeal. She may not get another trial. There may or may not be parts of the finding of the jury that is reversed, may not. They can do that on, the appellate court can do that on 1, 2, or 3 counts. There are lots of options that the appellate court has. The reason I say that is this. Mrs. Adelson, maintaining her innocence, could not have shown more remorse for the killing of Danny Markel. And in her statement, although some of it I know was bothersome to the court, in her statement, I hope you heard.
I wouldn't say bothersome to the court.
Okay.
Please continue.
Okay. I misread then. I apologize based on your comments. The defense's position in this case, from start to finish, has always been, on behalf of Mrs. Adelson, beyond respectful to the victim in this case, Danny Markel. He should not be lost in this case, and I said that in my opening statement. We presented evidence about a wonderful man he was. He did not deserve for this to happen. The Markels gave their statements at the conclusion of the verdict that was issued by the jury, and I listened to every single word. And every single word that they said came out of the terrible grief from the loss of their son and the feelings that they have developed over the course of this 11 years in prosecuting these various people and additional information that has been given to them. Every word they had every right to say. The feelings that they had are exactly what they should have. What happened to Danny Markel, as Donna Adelson has said in her statement, could not have been more horrific. He was treated like an animal, completely unaware that there was any kind of problem, that he would have any kind of physical altercation with anybody. I'm positive the furthest thing from his mind that day was that someone was going to kill him in his garage at his home. He did not deserve what he got. It's been very clear in the prior prosecutions and what was presented in Mrs. Adelson's trial about the conduct of these other individuals. They do deserve to be where they are. They do. Their conduct is unimaginable to me, that human beings would engage in that kind of conduct to bring a man, an innocent man, a well-respected man, an amazing father, to take him away from his mother, his father, his sister, most importantly, his children. That was horrific. I understand why those sentences were imposed. Not for Mr. Rivera, but for the ones that were tried and convicted.
As to the sentence in this matter, Ms. Adelson, please rise. Level of planning and coordination to bring the murder of Professor Markel to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub a Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, You are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1.